through the OLT. Just curious if we understand. Yeah, better be quiet.
Hello?
Okay, Mr. Chair, we're good to go.
Okay, very good. I would like to call the meeting to order at 9:07. And I will just say, and I don't have my script with me, but this is being live webcast. And if you are on it, your voice and image will be shown on the website and on the YouTube channel for the township. And you are consenting to that. And moved by Member Brown, second by Member Quinn, be it resolved that Committee of Adjustment agenda dated April 11th, 2023 be adopted. All those in favor? That's carried. Are there any declarations of conflict of interest? Yes.
I was involved in a property sale at A-1723, so I'll recuse myself from that one.
Okay, thank you very much. Any other conflicts? Okay. Moved by Member Stokes, second by Member Bridgman. Be it resolved that Committee of Adjustment dated March 13th, 2023 be adopted and approved as circulated. Are there any questions or comments? All those in favor? And that is carried. And Kitty, would you like to go over the rules, please?
Thank you, Mr. Chair. Good morning, everyone, and welcome. It's required that I make a few statements and then I'll explain the hearing procedures. This electronic hearing is being held in accordance with Section 238 of the Municipal Act 2001 due to the COVID-19 pandemic. The members of the Committee of Adjustment present are Alan Edwards, Barb Bridgman, Ruth Ann Brown, Lisa Grogan Green, Joe Quinn, and Sean Stokes. I confirm we have a quorum. I can also confirm that senior staff and planning staff are present. Public input on this April the 11th, 2023 agenda was invited at the following email address, planning@muskokalakes.ca. Now I will explain the hearing process. The planner will provide an explanation and purpose of the application, the date the notice was circulated, and planning staff's comments. All internal and external submissions were sent to committee members on Thursday, April the 6th, 2023. The planner will present any submissions received after this date. The committee will then hear from the applicant or the applicant's agent if they wish to add any information or to substantiate their proposal. Please provide your name, mailing address, and postal code for our records. The committee will hear from those in support of the application and those in opposition to the application. Again, please provide your name, mailing address, and postal code for our records. Presentations are limited to 5 minutes unless otherwise permitted by the committee. If you are here to speak on an application, please wait to raise your hand in Zoom until the planner presents the relevant application. The committee will then hear from the applicant or the applicant's agent to respond to any questions or concerns raised. The committee will then have the opportunity to ask questions. The committee will debate the application and make a decision based on the information presented at the hearing. Please note that the effect of written and oral submissions on decisions for consent and minor variances and the reasons for the minor variance decisions are both required under the Planning Act. and motions are pre-populated with standard wording. However, the committee may decide to add reasons and/or effects to the standard wording after voting on a decision. Motions have also been pre-populated with random movers and seconders to expedite the meeting. The motions are automatically written in the positive to assist in completing decisions as opposed to writing out each resolution. This does not in any way mean an application is going to be approved. When it is time to vote, members shall physically raise their hand until the chair has confirmed the vote. If the vote is unclear, a verbal vote shall be recorded. This is not considered a recorded vote. It must be noted that the chair has a vote on each application and can participate in the discussion. There's a 20-day appeal period from the date of the decision. Building permits are not available until after the appeal period and if no appeals are received. And lastly, please take down the pink notice signs that were posted on your property to advertise today's meeting. Thank you.
Thank you very much. I appreciate that. And the first application is B 3522 ML and also A 110-22 MacMillan and Funston, and that'll be Ms. Crowder.
Thank you, Chair Edwards, and good morning, members of committee. The first applications to be heard are concurrent consent application B 3522 ML and minor variance application A 11022 in the name of MacMillan and Funston. The subject lands do not have a municipally assigned address. I would direct committee's attention to the submitted consent sketch on page 41 of the agenda package. The purpose and effect of the applications are as follows: to create one new residential lot and to permit a development envelope to be 13.1 feet from a lot line abutting a public street, which is also considered the front lot line. Notice of this public hearing under the Planning Act was circulated 16 days in advance of this meeting, and 3 submissions have been received to date. The following comments were received and have been circulated to committee prior to today's meeting. Comments have been received from Nick Snyder, the township's chief building official, stating no objection to the application. Comments have been received from Tim Sopko, the township's public works technician, stating that the township's standard for road allowance width is 20.1 meters. The road allowance for River Street at this location varies between 20.1 meters and 10.05 meters in width. As a condition of approval of the severance, Public Works requests that the property be conveyed to the township for the purposes of dedication as road allowance to provide a minimum road allowance width of 20.1 meters along the entire frontage. Reduction in setbacks from the road allowance can present future issues, and Public Works would prefer that the setback from the road allowance be achieved where possible. That said, the constraints of the site and the existing character of the neighborhood provide justification for consideration of a reduced setback. Public Works can support a minimum setback of 13.1 feet as shown on the plan submitted. This is the minimum recommended setback to maintain the road allowance for future use by utility companies such as Hydro. If approved, the severance should be subject to confirmation of the availability of entrance permits for the retained and severed lots. Comments were received from the District Municipality of Muskoka stating that they would not be opposed to the approval of the applications, provided that the lands be subject to an agreement with the District Municipality of Muskoka pursuant to sections 5126 of the Planning Act, as amended, relating to district servicing, amongst other matters. Staff have prepared a detailed report for committee's consideration and have recommended that the applications be approved, subject to standard conditions of consent. Staff have no further comments at this time and are happy to answer any questions from committee. Thank you.
Thank you very much, Ms. Crowder. Excuse me. Is the applicant or applicant's agent here wishing to speak on this?
No, I don't think I need to speak at this time.
Okay, very good. Are there questions from the members? I don't see any. Okay, the resolution is moved by member Grogan Green, second by member Quinn. Be it resolved that consent be granted for application B 3522 ML MacMillan and Funston provided the following conditions are fulfilled. 1, a satisfactory registrable description deed of the separate lot, together with any required right-of-ways or easements, be submitted to the township along with a registered copy of the reference plan. 2, that the availability of an entrance permit for each of the retained and separate lots be confirmed by the Township Public Works Department. 3, that road widening be dedicated to the township to the satisfaction of the Township Public Works Department. 4, that cash in lieu of parkland be dedicated to the township in the amount of 5% of the assessed value of the severed lot or the entire lands, whichever is less. And 5, that lands be subject to an agreement with the district municipality of Muskoka pursuant to section 5126 of the Planning Act, RSO, as amended, relating to district servicing, amongst other matters. Are there any questions or comments? All those in favor? And that is carried. And we have one more on that one. Moved by member Stokes, second by member Brown, be it resolved that application A 110/22 MacMillan and Funston to construct a dwelling and accessory structures is hereby approved, with the following variance being granted: to permit a dwelling and accessory structure within a building envelope on the severed lot and in consent application B 3522 ML to be set back 13 feet at the closest point from the lot on River Street. This variance will be granted and as shown on the plan attached to the notice of decision. This approval shall remain in effect for 3 years from the date of decision. Any questions or comments? All those in favor? Thank you. That's carried. Okay, and the next application is B 10/23 Spencer, and that is Ms. Gilgan.
Thank you and good morning, Chair Edwards and committee. The next application to be heard is consent application B 10/23 ML in the name of Spencer. Subject lands are known municipally as 3164 Muskoka Lake Road, 118 West, Unit 21A. I would direct committee's attention to the submitted site plan on page 55 of the agenda package. The purpose and effect of this application is to permit a lot addition from abutting lands. The application is for a change in common lot lines only, and no new lots are being created. There is also an existing driveway which abuts the parcel to be severed and added to the benefiting property, which access rights are to be transferred over through this application. Notice of the public hearing under the Planning Act was circulated 18 days in advance of this meeting, and no submissions from neighbors or members of the public have been received to date. Comments were received from the District Municipality of Muskoka, the Township of Muskoka Lakes Building Services Division, and the Township Public Works Department, all stating no objection. Staff have prepared a detailed report for committee's consideration and have recommended that the requested lot addition application be approved, subject to the following conditions: that a registerable description deed of the severed lot and any required rights of way be submitted to the Secretary Treasurer along with a registered copy of the reference plan; that a legal undertaking be submitted in order to confirm that the severed lot will merge in title to the lot it is being added to upon registration of the transfer/deeds, which may require the cancellation of any previous consent, and that confirmation be received that the retained lot is satisfactory for on-site sewage disposal, and that any problems identified with any existing sewage system on the retained lot be corrected to the satisfaction of the township. Staff have no further comments at this time and are happy to answer any questions from committee. Thank you.
Thank you very much. And is the owner applicant agent here? Thank you.
Good morning, members of the committee. My name is Savas Fratis of Plan Muskoka. I'm here this morning representing the applicants as their planner and agent on this matter. I don't really have much to add. I think the application is fairly straightforward. It's basically, as staff has said, it's not creating any new lots. It's just simply taking a portion of the large retained lands existing behind the benefiting lands and adding it to the benefiting lands and providing for a right of way as well at the same time. There's no change in terms of like the lands that are being added are not utilized, they're vacant. So there's no impact on septic system locations or wells or anything like that for the retained lands that are being impacted by this proposal. Ultimately, what we have is a waterfront property that ends up being larger, about twice the size as it was before. So there really is no impacts in terms of reductions of the retained lands beyond a point which is acceptable. The retained lands are very, very large. So I really don't have anything more to add than that, but I'm happy to answer any questions the committee may have. Thank you.
Thank you very much. Is there anyone else here wishing to speak in support of this application?
No one in support.
Anyone wish to speak in opposition to this application?
No, there's no one in.
Okay, very good. Okay, are there questions from the members? Okay, I shall read the resolution. Moved by member Grogan Green, second by member Bridgman, be it resolved that consent be granted for application B1023ML Spencer, providing the following conditions are fulfilled. 1, a registrable description, deed of the severed lot and any required right-of-way be submitted to the Secretary Treasurer, along with a registered copy of the reference plan. 2, that a legal undertaking be submitted in order to confirm that the severed lot will merge in title to the lots that is being added to upon registration of the transfer/deeds, which may require the cancellation of any previous consents. And 3, that confirmation be received that the retained lot is satisfactory for on-site sewage disposal and that any problems identified with the existing sewage system on retained lot be corrected to the satisfaction of the township. Are there any questions or comments? All those in favor? And that is carried. Thank you very much. And the next application is B1223 Veitch, and that is Ms. Gilgan again.
Thank you, Chair Edwards and committee. The next application to be heard is consent application B-12/23ML in the name of Veitch. The subject lands are known municipally as 1706 and 1774 Windermere Road. I would direct committee's attention to the submitted site plan on page 78 of the agenda package. The purpose and effect of this application is to create a new lot. Notice of this public hearing under the Planning Act was circulated 15 days in advance of this meeting, and no submissions from neighbors or members of the public have been received to date. Comments were received from the District Municipality of Muskoka outlining requested conditions and requirements which have been incorporated into the recommended conditions of approval. Comments were also received from the Township's Public Works Department recommending that servicing be located on the property which it serves and confirming that the district should be circulated with regard to the public road. And comments were also received from the Township's Building Services Division stating no objection. Staff have prepared a detailed report for committee's consideration and have recommended that the requested consent application be approved subject to the following conditions. 1, that a registrable description deed of the severed lot and any required rights of way be submitted to the Secretary Treasurer along with a registered copy of the reference plan. 2, that confirmation be received that the township is satisfied that the severed and retained lots are satisfactory for on-site sewage disposal and that any problems identified with any existing sewage system on the severed and retained lots be corrected to the satisfaction of the township. 3, that a consent agreement be entered into with the District Municipality of Muskoka and registered on title under section 5126 of the Planning Act, respecting the location of wells in relation to District Road 4/Windermere Road. 4, that a 3-meter or 10-foot road widening across the frontage of the severed and retained lots be dedicated to the District Municipality of Muskoka for road widening purposes. 5, that a conditional access permit from the District Municipality of Muskoka for the severed and retained lots be obtained, or that proof of permit is provided to the satisfaction of the District Municipality of Muskoka. Staff have no further comments at this time and are happy to answer any questions from committee. Thank you.
Thank you very much, Ms. Gilgan. And is the agent or owner here? Okay, Mr. Lorenz, I believe it is. Go ahead.
Yep. Good morning, Chair Edwards and committee members. My name's Jack, and I'm representing the client from the Conan Group, Port Carling. I'm just here to answer any questions that you may have regarding the application.
We need your full address and
Oh, yep.
postal.
Yep, it's 3 Armstrong Point Road, Port Carling, P0B1J0, and then PO Box 340.
Okay, thank you very much. Are there any questions from the members? Seeing none, I'll read the resolution. Excuse me. Moved by Member Brown, second by Member Grogan Green. Be it resolved that consent be granted for application B1223 ML Veitch, provided the following conditions are fulfilled. 1, a registral description deed of the severed lot and any required right-of-way be submitted to the Secretary Treasurer, along with a registered copy of the reference plan. 2, the confirmation be received that the township is satisfied that the severed and retained lots are satisfactory for on-site sewage disposal, and that any problems identified with the existing sewage system on severed and retained lots be corrected to the satisfaction of the township. 3, that a consent agreement be entered into with the district municipality of Muskoka and registered on title under section 5126 of the Planning Act, respecting the location of wells and relation to the district road 4, Windermere Road. And 4, that a 3-meter, 10-foot wide road widening across the frontage of the severed and retained lots be dedicated to the district municipality of Muskoka for road widening purposes. And 5, that the conditional access point from the district municipality of Muskoka for the severed and retained lots be obtained when a proof of permit is provided to the satisfaction of the district municipality of Muskoka. Are there any questions or comments? Seeing none, all those in favor? And that is carried. And the next application is B1323 Smith. That is in Ms. Gilgan.
Thank you, Chair Edwards and committee. The next application to be heard is consent application B-1323 ML in the name of Smith. The subject lands are known municipally as 1025 Appian Way, unit number 8. I would direct committee's attention to the submitted site plan on page 91 of the agenda package. The purpose and effect of this application is to grant a right-of-way to abutting lands. Notice of this public hearing under the Planning Act was circulated 18 days in advance of this meeting, and no submissions from neighbors or members of the public have been received to date. Comments were received from the District Municipality of Muskoka, the Township of Muskoka Lakes Building Services Division, and the Township Public Works Department, all stating no objection. Staff have prepared a detailed report for committee's consideration and have recommended that the requested consent application be approved, subject to the following conditions: that a registerable description deed of the severed lot right-of-way be submitted to the township along with a registered copy of the reference plan, that confirmation be received that the township is satisfied that the retained lot is satisfactory for on-site sewage disposal, and that any problems identified with any existing sewage system be corrected to the satisfaction of the township. Staff have no further comments at this time and are happy to answer any questions from committee. Thank you.
Thank you very much. And I see that we have Mr. Allen here.
Good morning, Chair Edwards. Good morning, committee.
Morning.
My name is Ryan Allen. I'm the planner and agent representing Hugh and Beverly Smith at 1025 Appian Way, unit number 8. Address is 104 Kimberley Avenue, Bracebridge, Ontario, P1L1Z8. Thanks, Ms. Gilgan, for the summary of the application. It's a very straightforward application. There's an existing right-of-way that travels over the Smith property at unit number 8 that provides access to unit number 10. That existing right-of-way is proposed to be removed and replaced with the new proposed right-of-way that's located over an existing driveway. I'd be happy to answer any questions you have.
Thank you very much, Mr. Allen. And is there anyone else wishing to speak in support?
No.
Anyone in opposition? No? Any questions from the members? Seeing none, I'll read the resolution. Moved by member Bridgman, second by member Quinn. Be it resolved that consent be granted for application D 1323 ML Smith, providing the following conditions are fulfilled. One, that a registrable description deed of the severed lot right of way be submitted to the township along with a registered copy of the reference plan. And two, that confirmation be received that the township is satisfied that the retained lot is satisfactory for on-site sewage disposal, that any problems identified with the existing sewage system be corrected to the satisfaction of the township. Any questions or comments? All those in favor? And that is carried. And the next application is A1023, and that's Kingstone, and that is Ms. Crowder.
Thank you, Chair Edwards. The next application to be heard is minor variance application A1023 in the name of Kingstone. The subject lands are known municipally as 1114 Halls Road, Unit 2. I would direct committee's attention to the submitted site plans on pages 110 and 111 of the agenda package. The purpose and effect of the application is as follows: to recognize an as-built shed and attached sun deck. Notice of this public hearing under the Planning Act was circulated 14 days in advance of this meeting, and 4 submissions have been received to date. Comments have been received from Nick Snyder, the township's chief building official, stating that the combined area of the as-constructed shed and deck are in excess of 15 square meters. As a result of the size of the structures, and given they are constructed as one building, a building permit is required for the construction of this shed in excess of 15 square meters. Comments were received from Tim Sopko, the township's public works technician, stating no objection to the application. And 2 letters of support were received with the application at the time the application was submitted. These letters are from Jeff Reeves and Karen Cornell. I can read these comments in full at the request of committee. Staff have prepared a detailed report for committee's consideration and have recommended that the application be approved subject to the following condition: that a satisfactory minor variance agreement under section 45, 9.1 and 9.2 of the Planning Act be entered into and registered on title, wherein the owner agrees to utilize the as-built shed for storage purposes only. Staff have no further comments at this time and are happy to answer any questions from committee. Thank you.
Thank you very much, Ms. Crowder. And is the applicant or applicant's agent here?
I am the
Okay.
applicant.
You can turn your video on if you like.
Here we go. Hello. My name is Elizabeth Kingston. My address is 398 Wellesley Street East. I'm assuming you want my mailing address?
Yes, please.
Okay, 398 Wellesley Street East, Toronto, postal code M4X 1H6.
Okay.
And with my mother, I am the owner. And I am here to answer any questions. I have lots to say about my property in Muskoka and this shed that I built, but I know that I'm best to stay on topic and answer questions only, but it was built as overflow storage space because we have small buildings that are very old. And as I use the cottage more and more often, I find myself needing dry places to put tools, basically. And the property is on a hill. We have a single-story boathouse, and I'm just always shifting things. And the back of the property, it's difficult for me to carry things up and down. So I built this shed, and I know it's not compliant. So I'm trying to get a minor variance.
Okay, thank you very much. And is there anyone else wishing to speak in support? Anyone speaking in opposition? No, I'm just asking. Seeing none, other questions from the committee? Seeing none.
Yeah, I have a question, if I may.
Yes.
Yes.
It concerns the official plan, as it relates to habitable versus non-habitable space. And I understand that there is a requirement to put on title that this is habitable space. Maybe for my edification, if someone could explain to me how that would be policed, it would be appreciated.
Thank you, Member Stokes. Through you, Chair Edwards, if I may.
Yes.
So essentially, this structure, the minor variance agreement that staff's recommending would be an agreement where the owner agrees that they will only utilize the building for storage only and not as a habitable structure. And that's just sort of an added layer so that if it is used as habitable, we have a document on title where they've said that they would not use it as a habitable structure, but ultimately it is an enforcement issue. So if the structure were used as a habitable structure, this would be a bylaw enforcement matter.
Thank you.
Okay, any other questions?
May I comment?
Yes, you may.
I just think that I want one of these. It's obviously not storage. And I'm grateful to the planners for saying that this has to be storage in the future. I just want to make sure that that ensures that if the property is ever sold, this doesn't suddenly become something that's legal, non-complying, and it can be expanded or what have you, because we would all like to be within this distance of the shoreline.
Through you, Chair Edwards. Thank you for Grogan Green. Yes, so essentially this agreement is on title, so it will carry on to future property owners, and they will also be obligated to inherit this agreement where they agree that it will be storage only. If it were to be expanded in a matter in compliance with the bylaw, that would be permitted, but any proposed expansion that is not in compliance would be required to receive planning approvals. And again, any habitable use of the structure would be an enforcement matter.
Yes, Member Bridgman.
Thank you, Chair Edwards. Just to follow through on that, and this is probably to Mr. Sharp, because this is a huge issue here, and I think we're all aware of that. Mr. Sharp, is there any way when the township does the review of the comprehensive zoning bylaws that this can be tightened up somehow so it's easier to enforce? Because to Member Grogan Green's comment, it's very hard to enforce this. So are there steps that could be taken going forward to help us be able to enforce this?
Through you, Chair Edwards, and thank you for your question, Member Bridgman. Member Bridgman and Chair Edwards, as you would be aware as members of past council, staff brought forward a bylaw in 2021, bylaw 2021-116, looking at this exact very issue. And, staff considered putting some limitations on the number of accessory buildings that would be permitted on a waterfront residentially zoned properties within specific criteria and parameters. Council ultimately opted not to go down that path at this time, but it's certainly something that staff would be open to and willing to explore as part of a future zoning bylaw update. So I would just leave it at that for now, but if you have any further questions, I'd be happy to expand. Thank you.
Thank you. I'll ask Mr. Sharp a question. I'm looking at page 96, figure 1. And I don't believe for storage, you need that larger window at the side looking out over the lake. And I think what we should be doing in future is turning around and saying no windows in storage sheds or very, very small ones. And I see the applicant has their hand up. Yes.
I wanted to say that in building this shed, my contractor and I gathered materials from, like, the materials have been purchased based on what was available in a reuse it kind of way. And I realized they don't look like we wanted it to look nice. And we wanted natural light to be let in. I hear what you're saying, and I realize that it is contradictory, but in the planning, there was intentionality behind all of the decisions that we made. And I recognize right now that the optics of it are not in my favor. I don't know if members, I don't know who goes out and looks and sees inside the spaces, or if that has happened in the past 2 weeks. It is a shed. I wanted it to look nice. Yeah, that's what I'm saying. And I wanted natural light to be in there.
Okay, thank you.
And I'm 100% committed to this process, and, you know, if whatever is on title, like, I am a longtime Muskoka seasonal resident and am very committed to maintaining the integrity of the property and the buildings on it and moving forward honestly.
Okay, thank you.
Do the right thing.
Any other questions or comments? Seeing none. Moved by member Stokes, second by member Bridgman, be it resolved that application A1023 Kingstone to recognize an as-built shed attached sun deck is hereby approved with the following variants being granted. 1, to permit a front yard setback of 17.5 feet at the closest point for a shed, and 2, to permit a front yard setback of 18.5 feet at the closest point for sun deck. These variances are granted as shown on a plan attached to the notice of decision and are subject to the following condition. 1, that a satisfactory minor variance agreement under section 45, 9.1 and 9.2 of the Planning Act be entered into and registered on title, whereas the owner agrees to utilize the as-built shed for storage purposes only. This approval shall remain in effect for 3 years from the date of decision. Any questions or comments? All those in favor? That is carried. Okay. The next application is A1523, and that is 2573523 Ontario, Inc., and that is Ms. Gilligan again.
Thank you, Chair Edwards and committee. The next application to be heard is minor variance application A-1523 in the name of 2573523 Ontario Limited. The subject lands are known municipally as 1104 Barlokin Road. I would direct committee's attention to the submitted site plan on page 119 of the agenda package. The purpose and effect of this application is to construct an addition to an existing sun deck. Notice of this public hearing under the Planning Act was circulated 10 days in advance of this meeting. 2 neighboring property owners, Alan Detsky, whose property is directly across the lake from the subject property, and Frank Bracken, whose property is to the immediate south of the subject property, submitted comments in support of the application. These comments can be read in full at the request of the committee. Comments were received from the Township's Building Services Division and the Township's Public Works Department, both stating no objections. Staff have prepared a detailed report for committee's consideration and have recommended that the requested minor variance application be adjourned in order to receive an updated site plan prepared by an Ontario land surveyor and that any necessary additional relief be included in an amended application and recirculated. Staff have no further comments at this time and are happy to answer any questions from committee. Thank you.
Thank you. Thank you very much. Is the owner or agent present? I see we have Mr. Dennis.
Yes, good morning, Chair Edwards and committee. Len Dennis, assisting Marie Poirier's office with this application, representing the owner. The address is Marie's office is 44A King William Street, Huntsville, Ontario, P1H 1G3. I had an opportunity, obviously, to listen to the presentation and review the report, and we're satisfied with the adjournment, and certainly appreciate the efforts of and assistance of staff bringing the application forward. It will be revisited and come back to committee at a future date. Thanks.
Okay, thank you very much. And I do have to ask, is there anyone here wishing to speak in support of this application? Or anyone wishing to speak in opposition to this application? And it has been requested, and we will adjourn this application to a later date. Thank you. And the next application is A1623 Ferguson and Grogan. And that is again, is it Gilgan?
Thank you, Chair Edwards and committee. The next application to be heard is minor variance application A-1623 in the name of Ferguson and Grogan. The subject lands are known municipally as 1247 Rosso Lake Road 3, unit number 20. I would direct committee's attention to the submitted site plan on page 138 of the agenda package. The purpose and effect of this application is to construct a new 2-story boathouse. Notice of this public hearing under the Planning Act was circulated 10 days in advance of this meeting, and no neighboring property owners or members of the public contacted the township in relation to the application. Comments were received from the District Municipality of Muskoka, the Township of Muskoka Lakes Building Services Division, and the Township Public Works Department, all stating no objection. Staff have prepared a detailed report for committee's consideration and have recommended that the requested minor variance application be approved. Staff have no further comments at this time and are happy to answer any questions from committee. Thank you.
Okay, and we have Mr. Dennis again.
Yeah. Good morning once again, Chair Edwards, committee, Lennie Dennis, Planning, Box 254, Nova, Ontario, P0A 1R0. We're retained by the DeConing Group to assist with the planning process, and I had an opportunity to review the planner's report and listen to the presentation. I think that's a fair and accurate assessment of the proposal, and certainly concur with the planning department to approve the application as it does meet the 4 tests. Basically, just to reiterate and highlight some of the points in the report. The merits of the proposal, it's really only marginally over in terms of coverage. It's only 0.3%, which is 157 square feet in the overall coverage, and 0.4%, it's 190 square feet for the lot coverage within 200 feet of the shoreline. So it's really truly minor. It's really truly minor in nature. Basically, the mainland portion of the shore area will remain undisturbed. Because all the development being a boathouse will be out over the water. The owner has indicated they may also be interested in planting some additional trees if required. Having said that, the shoreline and the property is generally well vegetated with existing mature tree cover. The boathouse, other than the lot coverage, complies with all other performance standards. The siting of the boathouse is equidistant, pretty much more or less the same distance from the neighbors on either side. It's central to the lot, sort of lines up with the existing cottage, thereby reducing the face print of the built form along the shoreline. There's basically there are no other shoreline structures in the immediate area on either side of the proposed boathouse, and certainly would minimize impact. There shouldn't be an issue with respect to a visual impact on either abutting property. There's an elevation of land on the one side, and there's certainly very good tree cover as well, which will also help minimize any visual impacts. So that would be what I would suggest and conclude in terms of the merits of the proposal, and would respectfully request committee approve the application. Thank you.
Thank you very much. I have to ask, is there anyone else wishing to speak in support of this application? Anyone wishing to speak in opposition to this application? Seeing none. Moved by Member Quinn, second by Member Stokes. Be it resolved that application A 17/23 Ferguson Krogan to construct a new two-story boathouse is hereby approved with the following variance being granted. 1, to permit a lot coverage of 5,258 square feet or 10.3% over the area of the entire lot. And 2, to permit a lot coverage of 5,258 square feet or 10.4 over the area of the lot within 200 feet of the high water mark. These variances are granted as shown on the plan attached to the notice of decision. This approval shall remain in effect for 3 years from the date of decision. Any questions or comments? All those in favor? And that is carried. Thank you.
Thanks for your time. Have a good
Okay, thank you. And the next application is A 17/23, Desroche and Desroche, and that is Ms. Yilkin.
Member Quinn is leaving the room. He's declared a conflict.
Right. Okay, thank you.
Thank you, Chair Edwards. The next application to be heard is minor variance application A 17/23 in the names of Tobias and Decress. The subject lands are known municipally as 1013 Fife Avenue. I would direct committee's attention to the submitted site plan on page 166 of the agenda package. The purpose and effect of the application is as follows: to recognize an as-built sun deck. Notice of this public hearing under the Planning Act was circulated 12 days in advance of this meeting, and 3 submissions have been received to date. Comments have been received from Tim Sopko, the township's public works technician, stating no objection to the application. Comments have been received from Nick Snyder, the township's chief building official, stating that if the application is approved, a building permit will be required to legalize the as-constructed sun deck. And finally, a letter of objection was received following the circulation of comments to committee. This letter was submitted by Stephen Fauner on behalf of Don and Karen Lang, abutting property owners. I will now read this letter to committee. I have been retained by Don and Karen Lang, who own property at 1017 Fife Avenue, Windermere, immediately to the north and west of the subject land in this proposal. They are opposed to the application in its current form for reasons outlined below. The proposed deck addition was constructed without a building permit. In addition, I understand the previously constructed deck was also built without a building permit or not in accordance with a building permit. The location is in the front yard next to the water's edge, which is to be a shoreline vegetative buffer. The recognition of the existing illegal deck negates the propagation of a shoreline buffer in this location. The application must be viewed as though it does not exist. A deck in this location should not be permitted in this location. When considering the approval of such applications, alternative sites must be considered. There are alternative sites on the property which comply with the front yard setback of the zoning bylaw. The deck, which is subject to the application, facilitates the use of the deck for a hot tub. As a hot tub owner, I am aware that the water must be changed a few times throughout the year, depending on use. The wastewater in this location invariably drains to the lake given the very close proximity, resulting in chemicals and pollutants entering the lake. In addition, my clients have advised me that there is an existing restrictive covenant on the property regarding the prohibition of development in relation to setbacks from lot lines. Extensive building and tree cutting has taken place along the north lot line. The driveway and landscaping have also encroached onto my client's property, and their property was used for the staging of materials without permission. There has been a clear disregard for regulations that apply to the property and location of property lines. My client's position in objection to the deck location is supported by the following. The township recently amended its tree conservation and site alteration bylaws. These bylaws now have a setback of 50 feet instead of the previous 25 feet in communities and urban centers. This reflects the need to set back shoreline disturbances and structures near the shoreline. Shoreline lots in communities are to be treated in a similar fashion to lots in the waterfront designation. This is evident by the zoning bylaw requirement of a minimum of a 50-foot front yard setback for new decks and 40 feet for a legal non-complying deck. The updated official plan has noted concern for the retention of shoreline buffer areas. Section E 4.2b details the role of natural shorelines in buffering water bodies from impacts. A vegetated buffer shall stretch across the entire frontage for a depth of 50 feet. The proposal does not conform to this official plan policy. Section E 4.12 of the updated official plan details the rationale for front yard setbacks. Section E 4.12.5 states protection of natural habitat and minimizing environmental impact in the foreshore area. Additional rationale is also noted in the section. In section N3, committee must consider the cumulative impact of similar decisions, setback from the lake and buffering from the lake. This proposal has almost no setback and there is no buffering from the lake. In addition, section N3 also states all reasonable alternatives have been explored with respect to the nature of the proposed development to determine if the one proposed has the least impact on the natural environment and the character of the shoreline area. There are alternate locations on the property that comply with the zoning bylaw. The proposal does not conform to this policy. As such, the application should be refused by committee and the deck and hot tub relocated to a location that complies with the zoning bylaw. If you have any questions, please do not hesitate to contact me. I request that I be notified of any future meetings in regard to this application. Signed sincerely, Stephen Fauner.
Thank you very much.
Oh, sorry, staff have prepared a detailed report for committee's consideration and have recommended that the application be approved subject to the following condition. That a satisfactory minor variance agreement under section 45, 9.1 and 9.2 of the Planning Act be entered into and registered on title along with securities for retention of vegetation and plantings to revegetate the shoreline buffer and to implement this and other recommendations of the fish habitat assessment prepared by Riverstone Environmental Solutions Incorporated, dated March 2nd, 2023. Staff have no further comments at this time and are happy to answer any questions from committee. Thank you.
Thank you very much. As I see the owner and the owner's agents here, which would like to speak first?
Hi, members of the committee. My name is Savas Varadas again from Plan Muskoka, PO Box 5384, Huntsville, Ontario, P1H 2K7. I'm here representing the applicants as their agent, and as you can see, they are present here this morning as well. I'll be happy to answer any questions the committee may have. I'm just going to share my screen to bring up the site plan because I have a couple points I'd like to make, and I'd like to be able to point to. Am I able to do that?
If it's at all possible.
It says it's disabled at the moment. That's why I wondered if it's able to do that.
And it may not be. What you normally do is send anything you want in, and then staff can bring it up.
So staff have the site plan. Maybe I could just ask them to bring it up then as well.
Okay. Can that be done?
It should be part of the agenda package.
Are you talking about page 166?
You would, I can look at that if you'd like, but it just would be the site plan that was submitted with the application. I think it'd be the only site plan that you have in your package.
I believe it's on 166 if everybody has their agenda there.
Okay, well, I can speak through it then. In terms of, I just want to make it pretty clear. There is what you're seeing here is basically a replacement of an existing legal non-complying structure. So On the site plan, you would see a dashed red outlined area directly behind the boathouse and a label that said previously existing sun deck. That was an existing platform or sun deck that was on the property that was located legally on that location. It was grandfathered in on that location. What was constructed was a patio structure, which is being deemed a sun deck, and it was constructed pretty much the similar size and location as the previous sun deck, but not the exact size, not the exact location. So it needs to be recognized. It is a patio structure, so it's not a wooden structure. And it was built on an area where there was no tree removal required. It was just like a rock sort of platform, like a natural sort of platform that was just enhanced by putting down stone and flattening it out and leveling it out into a patio. There was a fish habitat assessment that was prepared by Riverstone Environmental to address the fact that that part of this shoreline is in a type 1 fish habitat area. The recommendations of the report indicate that there would be no negative impacts to the fish habitat, as long as the recommendations of the report were to be implemented. As you heard, staff are prepared to implement those recommendations through an agreement under the Planning Act for minor variances. That would be a condition of the approval, and the applicants have no issue with implementing that. There is a revegetation area that's being recommended by Riverstone Environmental to be implemented through that agreement, and that location is basically right behind the boathouse in the area where the previously existing sun deck was located. In terms of context, we are in the community of Windermere, so there is a distinction between community waterfront properties and regular comparable waterfront properties in the waterfront designation. Windermere House, the resort, is located directly across the street from this property, and to the direct east is the Windermere docks of this land. So there is this is sort of a bay that has a lot of existing shoreline development in the area. In terms of the location of the patio, it is in a location which is behind the boathouse, so it's somewhat shielded from view from the water by the fact that there is a structure in front of it, a two-story structure. There is some vegetation along the shoreline in front of it, and there's lots of vegetation in and around it as well too. In terms of visual impacts, the property itself is only at 8.8% lot coverage, where there's a maximum of 20% lot coverage permitted on these lands. So you can see, in terms of balance of built form and natural form, the property is already exhibiting a lower development standard than is permitted under the bylaw. This helps to alleviate the concern that maybe the balance of built form and natural form has been disrupted by the proposal. We also have the fact that the dwelling itself that's located on the property is located 108 feet from the water, so it's well beyond the front yard setback requirement. And there's a slope that gets down towards water, which is where this patio is sort of existing at the bottom of that slope. So you have like a vegetated slope, and the dwelling is high and behind the tree line in the distance as well. In terms of the property next door and the objecting property, it's a fairly large property, and the expectation is that any sort of development that occurs on that property would be in a far distance away from the proposed patio that you're looking to recognize here today as part of this application. There's a fairly decent side yard setback distance of about 50 feet that the patio is from the western side lot line, and it's vegetated with natural vegetation along that, so it's well buffered from that property. There's no expectation that there'd be any negative impacts in terms of privacy or views or visual impacts to the neighboring properties to the west. So I don't really have any more really to add than that. I'd be happy to answer any questions the committee may have, and if the applicants wish to say anything, I'd allow them to do so now, or would they be happy to answer any questions as well? Thank you.
Okay, thank you very much. I will just ask you one question. You said that this patio and hot tub were behind the boathouse, and yet I'm looking at page 155 and it's beside the boathouse. Is it not?
I would say, sorry, I would say it'd be partially behind. If you look at the site plan, if you're looking at the boathouse straight on, I would say about like a good, 50 or 60% of it falls behind that boat port section of it's basically a boathouse with a two-story structure and a boat port beside it with a deck in front of it. So it's sort of behind that western side of that structure.
Well, looking at page 155, the hot tub is completely exposed.
Okay.
Is it? Or is that in that picture wrong?
Let me just pull up my site plan here so I can look at it as well. The way I saw it was that the patio structure itself, about half of it is behind the boat port with upper deck, that's just labeled on the site plan. The hot tub itself appears to be beside the structure on the western half of that.
Okay, I just wanted to make sure I was right.
Yep.
Okay, thank you. Would the owners like to say anything?
Good morning, Chair. Good morning, Chair Edwards and members of the committee. Thank you very much for taking the time to listen to our application. I guess the process started where we had a situation where the decking for our boathouse was wood construction and it was starting to decay and we had a problem. So we hired a local contractor to proceed with the resurfacing of the decking of our boathouse, which if you look at the various pictures throughout the application, you'll see that there was new decking performed. In that process, they did remove the existing sun deck that we had, and it was deemed at that time through our contractor and us that the best way and the most integral way to make it as safe as possible to reconstruct the surface as it was being reconstructed on bedrock that was existing and plateaued was to surface it with natural granite stone. So that's sort of the process that we took upon. Unbeknown to us, I did not know that, actually my wife and I did not know that we needed a building permit in order to reconstruct. So in hindsight, had we known, we would have applied for a building permit in advance of this happening. I'd just like to talk a little bit about Mr. Fainer's letter. And in his letter, he states that there was numerous amount of trees removed from the property. That's actually false. There was 4 hemlock trees that were overgrown and falling over the boathouse. Those are the only trees that have ever been removed from the property. There was a permit taken by the arborist that we hired to perform this work. They did apply for a permit and they did deem that it was due to a safety issue, they needed to be removed. In regards to the drainage of the hot tub, we have plumbing in our boathouse. We have our boathouse is connected to our septic system. There's nothing that will be drained into the lake. We're very environmentally friendly, and in no way do we intend to use our beautiful lakefront as a drainage issue for our property. The Langs, our neighbors, Mr. and Mrs. Lang, there was an encroachment issue that occurred when we originally were doing our property. There was a notice and we had bylaw officer Robert Kennedy come out to our property on September, I believe it was September 20th, 2021. And at that time, Robert Kennedy came to observe the whole property as he received a complaint of site alterations within 200 feet of the waterfront. Mr. Kennedy was very nice. He went through the whole property. He remeasured every single deck that we had on the property. He took a look at any site alterations that were made in regards to our driveway, landscaping, existing decks that were reconstructed. The only matter that he found as a contravention to what was existing was the positioning of the sun deck and the reconstruction as it altered in size and sort of shifted over from what was existing. Basically, this has been very emotional for us, so I apologize. It's a situation where this is our happy place. We are not here to upset people. We are not here to cause problems with people. We are genuine people, we're professionals, and we respect our neighbors. The community has been tremendous to us, and we embrace them. Our neighbors at the marina, our neighbors across the bay from us, they've countlessly sent us text messages, emails, stating that how beautiful our place is and how fortunate we are to be there. We're so happy. We just want to Like our neighbors had an application. We are moved that came forward in February. At that time, we were not interested in opposing them or having any complaints on them. We wish them well. We just want to be able to move forward. If there's things that have been wrong, we want to correct it. No one's here to encroach on other people's property. We respect our neighbors, and we want the healing process to begin with our neighbors.
I would just add that we aren't the type of people to disregard laws. I'm a lawyer. My husband has his own company. We are not here to disregard any laws. Anything that has occurred, we have quickly corrected, and we did not know that this was an issue. It was an existing area. We thought we were beautifying it, putting the stone, making it look better. We did not realize that that was an issue. But as soon as we became aware of any issue, we have always acted quickly and immediately to correct it, including, unfortunately, with the driveway where there was a small encroachment issue, which we immediately corrected the next day in terms of moving the rock over. So we are not trying to upset people. We do not intend to disregard any laws. That is not the type of people that we are. We have every intent to comply with all laws.
We were very, sorry, one last item. We were very happy to hire our environmentalist to give us a report, to give us options and what we can do, and whatever's required in order to beautify our lakefront. We are definitely interested in proceeding with that. That's second to none. We do love the space that we do have. Thank you, Chair and members of the committee.
Okay, thank you. Are there any questions from the members?
Excuse me, Mr. Chair, it's Mr. Sharp here. I just need the applicants to state their names and their mailing address for our record. Thank you.
Sorry, it's Adrian DiBiase and Stella DeCresce, 25 Bucks Place, Woodbridge, Ontario, L4L 3P9. Thank you.
And before I take the questions, is there anyone else who wishes to speak in support of this application? Anyone wishing to speak in opposition to this application? I see Mr. Fawner is on the screen.
Yes, thank you very much, Chair Edwards. Steve Fawner, Northern Vision Planning Limited, 109 Meadow Heights Drive, Bracebridge, Ontario, P1L1A4. Thank you to staff for reading out my letter in full. I think it'll reduce my comments, but I do represent Don and Karen Lang, who are the immediate owners to the north and to the west of this property, and their address is 1017 Fife Avenue. I do want to emphasize a few things, and I do want to add a couple of comments regarding the official plan as well. Again, Don and Karen Lang should be on this. I don't see their name up here, but they did intend to speak. The tree removal that I referenced was tree removal along the north lot line, the entrance into the property. There has been extensive tree removal, and my clients have given me photos over the years as to the change. But nonetheless, this is something at the waterfront. So really, the tree cover, I guess, may not be directly germane, but I would suggest that certainly there has been some significant changes on this property. I would also note too that, this is an existing deck, we'll call it, but because it's was done without a permit, you do have to look at it as though it's a brand new deck. And would it be approved in that location? Noting that the deck does contain a hot tub, I know that staff is trying to do the best they can with trying to provide agreements. Enforcement is really the key, and I'm not sure whether the contractor who's ever, who's ever going to be maintaining the hot tub, whether they're going to know that they can't discharge the water into the lake. The other thing is I'd be interested to know if the septic permit has taken into account the discharge of a hot tub into the tile bed. I doubt very much the septic permit does include that. That is something that should definitely be verified. I would then go to the official plan policies. And contrary to what Mr. Veratis has said, the new official plan, updated official plan says, where residential development occurs on the waterfront within a community area, the policies of section E4 to E7 of this plan apply. E4 to E7 is the waterfront designation. So those policies definitely apply. And I'll just read a couple of portions here quickly. In section E5 under site alteration, it is recognized that this plan strictly limits lot coverage in an effort to protect character and natural form, amongst other features. It is also recognized that development which does not contain a roof, such as a patio or a sun deck, can also result in extensive site alteration and tree removal, which may negatively impact character, natural form, and environmental integrity of the property. I will go on to section N3 N3, and just point out there are things to consider by committee. And this is a new section in the official plan. It says, in addition to the criteria established in the Planning Act, for minor variances, council shall also consider the following. Number one, all reasonable alternatives have been explored with respect to the nature of the proposed development. Now, my opinion is that this, the hot tub and the deck could be located in a location that does comply with the zoning bylaw. Number two, all impacts on natural environment landscape will be minimized. Number three, a reasonable vegetative protection zone adjacent to the shoreline shall be protected or enhanced. And item 7, the precedent-setting nature of the variance is considered with respect to the cumulative impacts. Again, we have virtually no setback here and no buffering. And I agree with the chair that this is in a different location than the previous deck. It's beside the boathouse, it's not behind. And lastly, the cumulative impact of amendments on this and other lands will be given greater weight than site-specific considerations. So I think it's a little bit of a challenge there. We have a situation where you have a deck there with no setback and really no shoreline vegetative buffer. And there needs to be consideration for alternative locations, which there are definitely alternative locations on the property. So in my opinion, it doesn't conform to the official plan, so it does not meet the 4 tests of a minor variance. Those are my comments, and I'm here to answer any questions. Thank you.
Thank you very much, Mr. Fawner. And we see we have a question from Member Bridgman.
Thank you, Chair Edwards. I actually have a couple of questions, if you'll allow me that. The first one is, are we sure that the first deck was legal non-complying? Can I ask of staff how we know that this was legal non-complying to begin with?
Thank you, Member Bridgman, through you, Chair Edwards. We did try looking through some aerial photos. It's not super clear in this case. So we did seek confirmation from the applicant and their agent, and they provided written confirmation of when the structure was originally in place. Additionally, there was a previous approval on this property dating back to, I believe, 2005, where there's a site plan that does show this sun deck structure on the approved site plan. So that is alongside the applicant's word is what we are basing this off of.
Okay, thank you. I think the applicants are fairly new owners, are they not? I'm guessing. But my second comment, I mean, we were talking that the hot tub is not allowed where it is. So that in itself, and I'm again hoping that this comes into bylaw, the hot tub has to be much farther back from the shoreline. So I am thinking this the sun deck was put in place for a hot tub. So I think the whole thing needs to go back and be complying at this point. So I am not in favor of approving this as it stands at this point. And to Ms. DeCressy's comments, they want to do everything legally, then the hot tub has to be back. I think it's 40 feet, 45 feet. I can't remember so much. So those are my comments.
Through you, Chair Edwards, it's Mr. Sharp here. I just, through you, I'd like to just clarify Member Bridgman's comment with respect to hot tubs.
Okay, yes, go ahead, Mr. Sharp.
Thank you, Chair Edwards. I just wanted to note that in this particular circumstance, the hot tub would not be considered a structure under the township's zoning bylaw. I would note that staff have been dealing with a lot of different types of hot tubs of all different designs, shapes, sizes. Some are permanent fixtures on a property, and some are in many ways portable features. And in this particular instance, based on our site visit to the property, we could not make the determination that the hot tub in question is a structure, and therefore we don't feel that it's regulated under the township's comprehensive zoning bylaw. It's clear that hot tubs are not permitted on a dock or a boathouse, but this situation is rather unique. And what I would note is that I feel that going forward into the future, we need to get a handle on hot tubs. And I think one way of solving these discrepancies that come up from time to time would be to specifically include a hot tub define it as a structure in the township's comprehensive zoning bylaw. So I just wanted to make that clarification for you going forward. I would note that the fish habitat assessment that's been undertaken by Riverstone has included specific recommendations with regard to the discharge of water from the hot tub. And staff have recommended that fish habitat assessment be included as part of an agreement that would be registered on title. Again, it is an agreement. Enforcement can be difficult, but having agreements registered on title does assist with enforcement when these matters do arise. So happy to elaborate further if needed. Thank you.
Yes, supplemental member Bridgman.
Thank you, Chair Edwards. Thank you, Mr. Sharp. I, having sat on council for a long time, was not aware we have different designations for hot tubs. So I'm going to suggest that maybe that's a quick one that could be put through fairly quickly. But now that you have explained that to me, there isn't a legal basis for my comment on the hot tub. And so I am not seeing this small structure. No trees were removed. If we've got vegetation going around it, I actually don't see denying this application.
Okay. Are there any other, sorry, Mr. We're in committee, you should realize that. Are there any other questions? I would just ask Mr. Sharp that it was stated that the hot tub would be drained into the plumbing going to the septic tank. I would like the plumbing inspector to make comment on that in the future, because it's chemicals and it could offset the effect of the septic system. I don't know if the plumbing inspector is in today, but I would like a reading on that.
Thank you, Chair Edwards. Could certainly review that matter with the township's building inspector that's specializes in on-site private sewage disposal. But what I would note in my experience, and based on the recommendation that Riverstone has included in the fish habitat assessment, it's often recommended that any chemically treated water be discharged some great distance, typically, upwards of 30 meters away from a water body, allowing it to infiltrate naturally through a shoreline buffer, which I believe is what would be the case in this instance. At least that's what the qualified environmental professionals are recommending. Thank you.
Okay, thank you. Are there any other questions? Yes, Mr. Stokes, I believe.
I share some concerns of the letter of the neighbors when I was reviewing the materials. I guess one of the questions is, have alternate sites been looked at for this hot tub on the property, as was suggested by the neighbor? I find the variance quite large, 36.4 feet versus 40. The issue raised with the septic system and its ability to accommodate the water is something that I wasn't aware of and didn't think of. So I guess we've dealt with that, but it does sound somewhat concerning. Similar question to the one I asked before, which is with regard to the discharge of any chemicals and water from a hot tub. I understand that it'll be on title, but I'm assuming that the only enforcement or monitoring of that would be done if, for example, a neighbor called the bylaw officer and the bylaw officer came out to take a look. So those are my questions and comments on the application.
Are there any other questions or comments from the committee?
Through you, Chair Edwards, it's Mr. Sharp here. I'd be happy to respond to Member Stokes' questions if able.
Fine. Yes, that's fine. Thank you. Go ahead.
Yep. Thank you, Chair Edwards. I think we've largely addressed the questions with respect to the hot tub. I'm happy to elaborate if needed, but the one distinction that I did want to make was with respect to our adopted and approved official plan and the policies that are contained within that official plan, and the adopted but not yet approved official plan. The adopted but not yet approved official plan was adopted in October of 2022, and it contains a specific policy that indicates that any applications that are received after that date and deemed complete, regard would be had to the policies. And, staff are working through what having regard to specific policies means in this instance. And what I'm hearing from Mr. Fauner and members of committee is that there's concern about what extent consideration has been given to alternatives. And it's a difficult, it's really a difficult, question to answer. I'm sure there's many alternative locations on the property. I would say that policy largely has been tested. But I think, we've had regard to the policies. We're comfortable that it conforms with the township's adopted and approved official plan. And, the sun deck is quite small in size. It's constructed of permeable materials. There's been a fish habitat assessment undertaken, and that will be implemented through an agreement. So I think we're largely comfortable with the application as indicated in our recommendation, but happy to elaborate or answer any further questions. Thank you.
Okay, thank you. I'll just ask one more time. Are there any questions or comments from the committee? Seeing none. Moved by Member Bridgman. We'll have to change that to the second. We can't have Member Quinn, so we just change that, Kitty, to Member Stokes.
Chair Edwards.
Yes.
It's Mr. Sharp here. Member Grogan Green had a question. She had her hand raised.
Oh, I'm sorry. The way the camera is situated, it makes it very, very difficult to see, and that should be more of a close-up. Okay, sorry, and that Member Grogan Green, go ahead.
I just have one comment. I wanted to double check that this is in fact a permeable patio. Is that like a dry mortar or something? Because to me, that looks like cement.
For you, Chair Edwards, to Member Grogan Green, I was on site, and the patio is not permeable. It is I believe the applicant described it as granite, and it doesn't have permeability to my knowledge.
Right. So like from my perspective, when I read all of this without understanding that the hot tub was not a structure, but I just thought, in light of the fish habitat and learning that it was a mix, I would just knock that down, throw it into the lake, and give the fish an opportunity to live there and do their thing. Because to me, It's clearly beside the boathouse. It's not behind the boathouse. I'm also worried about like the permeable pathway where the deck used to be. That could be vegetation. It looks to me like it's maybe a roadway for a golf cart or something. I have no idea, but I don't think it's on the site plan. When I took a look, it looked like that was on the site plan. I see a set of stairs, but I don't see that pathway. And I know that Riverstone has come up with a very good revegetation plan. It's definitely needed because you can see next to the stairs that there's sort of a wet area that's right now a bit of a tributary down to the lake. And, you know, already the applicant is saying that they want to drain it into their septic when actually the environmental study said to do something else. So I just generally don't like this. And I understand the complaints. You know, in my mind, it's an illegal hot tub. As I thought it was defined, I understand it's not, but this to me is not a permeable thing at all. And I don't know whether there were trees there before or not. I don't know whether there were trees where the pathway is, that with the granite path. I don't know. I'd have to look at old site photos. But I don't like this. I don't know how anyone else feels.
I'm hearing from members that there might be, I guess I'm going to ask the owners, would you like this adjourned to address these problems? I'd hate to see it turned down at this point, and maybe there is another location. I would like to see hot tubs back. You know, our strategic plan says environment first. And that's, so this is why I think the members are asking all these questions. What do the members feel? Would anyone like to see this adjourned?
I just like to understand whether or not alternative sites have been evaluated on the property.
Okay, well, all of that, so that's what I'm asking. Member Bridgman?
I think it would be helpful, Chair Edwards, to have the question of the septic with the drainage from the hot tub, not just for here, but going forward.
For everything. Yeah, I totally agree with you. I think that this is something that, and that we've been saying to move hot tubs back from the lake for this reason. And that, yes, might be people that, you know, follow it to the letter. Future owners could be dumping in the lake and people swim in that lake. It's a beach area. It's our beach area for the Windermere. So would we like to see this adjourned and get the questions of another location of the plumbing inspector's report, the building inspector's report on drainage?
Through you, Chair Edwards, it's Mr. Sharp here again, just hoping to clarify what we're asking to follow up on when this matter returns, if it is in fact adjourned. But based on what I'm hearing, it's consideration of alternative sites and perhaps the applicants or the applicant's agent can confirm those details now. Confirmation from one of the township's building inspectors with respect to the discharge of wastewater from the hot tub. That's certainly something that could be looked into. But, you know, based on what I'm hearing, it seems like the concern is largely with respect to the hot tub. Perhaps there's some consideration that could be given to just not permitting the hot tub, or that the applicants would agree to remove it from the as-built sun deck. Again, just throwing out ideas, but that's what I'm hearing.
Well, this is what I'm saying. If we adjourn it, we can get all this here sorted out and maybe they can move it. Like, I don't want to turn it down, and it may be turned down, and that it might be wise to adjourn it. And that I'm asking if they would like to adjourn it this time to see, because I do have some questions myself on it. And that because, like I say, we're looking at the environment and everything else like that. So I'm asking the committee, would you like this adjourned? Can I get a nod of heads or a show of hands? Okay, then I think it's wise that we adjourn this. Okay, and it can come back at a later date with everything answered. Thank you very much. And I
Thank you.
think at this point, we'll take a 10-minute break and then we'll get the next application. Thank you. As soon as everyone is ready, we can put the meeting back in order. Can everyone come back as soon as possible? Thank you. Are we just waiting for Member Stokes? Are we ready to resume?
One moment, Mr. Stokes is just arriving.
Okay, thank you.
Okay, we're good to go. Thank you.
Okay, is the video started? Then I'd like to call the meeting back to order. And next application is A 3922 Desroche, and that is Emily Crowder.
Thank you, Chair Edwards. The next application to be heard is minor variance application A 3922 in the name of Desroche. The subject lands are known municipally as 1112 Skeleton Lake Road 3. I would direct committee's attention to the submitted site plan on page 173 of the agenda package. The purpose and effect of the application is as follows: to construct a dock, sun deck, and sleeping cabin. Notice of this public hearing was originally circulated back in October of 2022. The application was originally adjourned by committee, requesting that the application not return until such time that the proposed sun deck and ramp be redesigned to comply with the minimum required setback from a lot line abutting a public street, that water depths be provided at intervals along the full length of the proposed dock, and that a satisfactory study be prepared by a qualified professional to address potential impacts to fish habitat. A revised proposal has been brought forward, which complies with the minimum setback from a lot line abutting a public street. Water depths have been provided at intervals along the proposed dock length, which are reflected on the submitted sites plan. These measurements were taken by the applicant during the summer months. Finally, a scoped fish habitat assessment was submitted to the satisfaction of the township. Comments have been received from Nick Snyder, the township's chief building official, stating that a building permit is required for the relocation or reconstruction of the sleeping cabin. Should the proposed cabin include plumbing fixtures, a sewage permit application is required, and the system to service the building shall be located on the same property. Staff have prepared a detailed report for committee's consideration and have recommended that the application be approved subject to the following condition. That a satisfactory minor variance agreement under section 45, 9.1 and 9.2 of the Planning Act be entered into and registered on title, along with securities for retention of vegetation and plantings to revegetate the shoreline buffer, and to implement this and other recommendations of the fish habitat assessment prepared by Riverstone Environmental Solutions Incorporated, dated November 21st, 2022. Staff have no further comments at this time and are happy to answer any questions from committee. Thank you.
Thank you very much. Is the applicant or applicant's agent here wish to speak on this?
Yes, hi, Adam Lennie, the permit guy, 35 Covered Bridge Trail, Bracebridge, P1L 1Y1. Through you, Chair. Good morning, committee. I just wanted to familiarize you with this application and talk about some key points. With regards to the decks, the cottage was built in the late 70s, has been in the family for a few generations. They do not want looking to increase any lot coverage of a small cottage, just the usual usable space outside and in keeping in line with neighboring properties. Since our last committee meeting, we have removed a deck at the rear of the cottage at the request of the township in order not to encroach on that rear setback. There was a deck originally built on the east side that came out with some large steel beams for support. The beams are still there today. It's just the wood top that is rotted and has been removed for safety over the years, but would like that to be replaced. The deck design has gone through several design variations of planning in order to keep existing setbacks in mind. The proposed deck layout will give a greater function to their property and allow egress for all ages to enjoy their property. There is a previous setback variances to the neighbor to the west for precedent. With regards to the dock, there is currently no dock there now, but even out at 73 feet, it is only 5 feet deep at optimal summer water level. So in the summers with little rain and precipitation, there is very little water to moor a boat. A fish habitat study was completed and is back, and no concerns were stated within that report. And the homeowners are fine with the plantings that are noted in that report. The Shore Road purchase was started last July, and I would assume would be completed shortly, and that will be done prior to any dock permit submission. Currently, all immediate neighbors have docks of similar size and projection with the shallow waters. It's just the nature of that side of Skeleton Lake. Once again, this is something just to add functionable for mooring their boat in deeper waters. With regards to the cabin on the back lot, it is only 143 square feet and very unsafe. If approved, it will be torn down and rebuilt with a setback of 15 feet to the west of the existing hydro line and will comply with all other setbacks. I'm here if you have any questions, and thank you for your time.
Thank you. Is there anyone else wishing to speak in support of this application?
No one else.
Or anyone in objection? No one else? Okay. Questions from the members? I have one. Looking at page 173, you're showing out 5 feet of depth there. We have had other reports from other environmentalists. You don't need 5 feet to talk about. And that we normally say 30 inches, and within 66 feet, it's 36 inches. And that's so why do we need 5 feet? And I'll ask, I guess, our planners and that there and that.
Sorry, Chair Edwards, it's Mr. Sharp here. I'm just I'm not quite following along here. You're noting a measurement on the site plan?
Yeah, it says approximately 36 inches in that, and that's well below the 66-foot setback. And then they're showing basically 60 inches, which is 5 feet at the end of the dock. And what I'm saying, you don't need 5 feet of water to dock a boat. And that, can you see that, Mr. Sharp, on page 173?
173.
Through you, Chair Edwards, he was just looking at the wrong page there. Just one moment. Through you, Chair Edwards, I will attempt to answer your questions here. So yeah, I see at the end of the dock, it says water depth approximately 60 inches, and within the 66 feet, it says water depth approximately 36 inches. In the report that they submitted, I believe the environmental professional stated that this water depth is what would be required to properly navigate their boat. But I don't know if the township has a standard water depth that we typically use to deem what is and what isn't acceptable to moor boats in and out. If there is one, I would maybe look to Mr. Sharp or Mr. Pang. But I think typically in these cases, we go by the recommendation of the environmental professional.
Yeah, through you, Chair Edwards. The township doesn't have a standard requirement for water depth for navigation. There may be other factors involved. I'm not a boater myself, but it sounds like you're of the opinion that 36 inches is the minimum required water depth for marine travel, but perhaps I see Mr. Lennie has his hand up and perhaps can provide some insight as well here. Thank you.
Okay, thank you.
Through you, Chair. Yes, I mean, you could say that 30 inches is good enough for a boat, but when it's August and we get no rain, that's down a foot and a half, then they're kind of beat again, which is the real reason for the request, because of the fluctuation in the lakes in the last even decade, with droughts and whatnot. We feel that we would need this depth. Even if you get a wakeboard boat, they draw more than not 30 inches, but they would draw 24 with an outboard or with an inboard propeller and the steering fin sticking down. I don't think what we're asking is unreasonable, but I'm sure we're here for discussion.
Well, yes, Member Quinn.
Yeah, I guess the original report probably had pictures showing us maybe what's along the shoreline and what is kind of maybe more standard in the area. And when I push the initial staff report here further down in, it won't open up for me. So maybe we can look at those pictures.
Okay, thank you.
Through you, Chair Edwards, I can confirm the original staff report does have photos in it, and I'm just trying to click it here myself. What I may be able to do is pull up a photo of the original shoreline pictures that I might be able to share.
Mm-hmm.
You, Chair Edwards, I had to go back to the minutes in the township documents to find that report too, because it doesn't come up. But also, if you allow me to go on, it was obvious the other docks in that area are longer than this dock. So the other docks have been accommodated. So that's just my comment on that.
And while I'm waiting for that picture to look at what's normal in the area, if we're into a bit deeper water and they come in and they put it in reverse to do other things, there's probably going to be less bottom disturbance and less siltation. So if it's 5 feet, they probably won't bother the bottom of the lake at all. So if it's normal to the area, I'm in support of this.
Okay.
Through you, Chair Edwards. We've just pulled some photos up on the screen. Hopefully you're able to see those. Those would be the abutting neighboring properties and their current shoreline structure development.
Okay. The picture that you're showing there now, can you tell me how long that is, that dock?
Through you, Chair Edwards, I don't know. I didn't go out and measure the dock. I can say that you can see sort of in the photo, there's a bit of a coloration difference where you can see that it's quite shallow for a distance out. But no, I don't know the length of the neighboring dock. Perhaps the agent for the application might know.
Okay, thank you.
Through you, Chair, if I may.
Yeah.
There was a good aerial photograph satellite that showed all the docks going east and west in there, all out to similar lengths. So this wouldn't stick past any further than those. That dock that last picture we're looking at, which is to the east of the owners, it actually tucks back into a bit of a bay there. So although I didn't physically measure it myself, it is definitely beyond the 66 feet and also in keeping in with what we're proposing today. Because all the docks, all that south shoreline of Skeleton Lake is all very shallow and sandy. And then there seems to be, like, as you saw in that picture, a defined dark line that it starts to drop off considerably there. So we're just trying to get the end of the dock to that so that they can moor their boat at that. And then if they have smaller boats and stuff like that, I mean, they can be in shallow area and they can, you know, hit the sand if there's not going to be, it's not going to be detrimental to their boats, but an inboard or an inboard outboard boat, just with the way how the water is going up and down the last decade or so is the ask for the request on this. Thank you.
Okay, thank you. Okay, are there any other questions or comments? Seeing none, read the resolution. Moved by Member Bridgman, second by Member Grogan Green. Be it resolved that application A 3922 Desroche to permit the construction of a new dock on a waterfront lot, to permit construction of a new sun deck on the waterfront lot, and to permit a relocation of an existing sleeping cabin on the back lot is hereby approved with the following variants being granted. 1, to permit a new dock to be undersized on an undersized lot. 2, to permit a sleeping cabin to be relocated, reconstructed on an undersized lot. To permit a sleeping cabin to be relocated, reconstructed on a lot prior to the establishment of the main use dwelling. To permit a sun deck to be 13 feet at the closest point from the northwesterly interior side lot line. 5, to permit a sun deck to be 10 feet at the closest point from the southeasterly interior side lot line. 6, to permit a dock to be 10 feet from the southeasterly side lot line projection. And 7, to permit a dock to be 73.5 feet in length. These variances are granted as shown on a plan attached to the notice of decision and are subject to the following condition: that a satisfactory minor variance agreement under section 45, 9.1 and 9.2 of the planning act be entered into and registered on title, along with securities for the retention of vegetation and plantings on the revegetation of the shoreline buffer, and to implement this and other recommendations of the fish habitat assessment prepared by Riverstone Environmental Solutions, Inc., dated November 21, 2022. This approval shall remain in effect for 3 years from the date of decision. Any questions or comments? All those in favor? And that is carried. Okay, and then we have under new business, we have site visits, and that'll be Kitty Bedington doing that one.
Thank you, Mr. Chair. This is prepared in response to the discussions the committee had earlier. Staff have a recommendation before you that the procedural bylaw be amended to prohibit site visits by committee members, and we're interested in your feedback.
Okay, has everybody read that?
I read it. I obviously, what am I going to say? I think it's undemocratic. I thought that as long as we didn't discuss anything, we were allowed to go out. It's not considered a meeting. There's been several situations where I've gone on a site and seen things that have taken place that have helped me make the decision. I have done my best based on the recommendations of the people that I, met at an OACA conference, that you're not really supposed to talk to the applicant. So I was very careful about not doing that, or even neighbors. And I just think it's a shame that we're now not even allowed to drive by a place on a boat to check out the shoreline, and whether whether there's built form on the water, and where a cottage sits relative to the tree line, which is very difficult for a planner to capture if they're not in a boat. And so I think it's, personally, I don't like this. Is it a bylaw? I'm sorry, I read it quickly last night, but I'm surprised that it runs contrary to what a lot of other municipalities do, because it's not what I was told at a big meeting where I met people from lots of different committees. So yeah, I think it's onerous and unfair.
Okay, Member Bridgman.
Thank you, Chair Edwards. I'm having difficulty with this also. I'm wondering if it could be simply that members of the Committee of Adjustment may not step on the property of those that are under application, and that means you can drive by, and you can drive by on the water, because to Member Logan Green's comments, sometimes actually seeing the actual property is very, very helpful. So I would be in support of this in terms of not actually stepping onto the property or contacting the applicants, but certainly being able to go and visually see as much as we can from a distance.
Anybody else? Go ahead.
I guess the question on that arises, and there is a fair amount of discussion in there on the liability issues, and I don't know how that would impact the ability for members to independently drive by in a boat.
Thank you. This is great discussion. Thank you for your comments. I think staff did struggle a little bit with the ultimate recommendation in this case, but we do feel that it is the appropriate recommendation. And one of the main factors that we had considered in making the recommendation was just that the liability that the municipality takes on in allowing non-staff members to undertake site visits to some properties that are accessible only by water, some properties that are rather remote in rural areas. We did do an analysis of some different municipalities, and it seemed like they all have different requirements. Some of the municipalities we looked at were in urban centers in an urban setting. As you know, our municipality is quite rural, and our staff go through quite a diligent process of ensuring that they're making note of properties that they're visiting, providing me with a list before they leave, checking in and out once they arrive and leave a property. So it's quite a detailed process and health and safety considerations that we apply to our staff site visits. So, that was one, I guess, again, just the liability, but, happy to go back to the drawing board and look at this more, or alternatively, we could move this forward today. Thank you.
Member Bridgman.
Well, perhaps, thank you, Chair Edwards. Mr. Sharp, perhaps we could go back to our lawyers, because the liability argument is, I'm having difficulty with that liability argument. You're not on their property. I'm not sure how the township then becomes involved. If somebody's in a boat and has a boat accident out in the middle of the water, why does that involve the township? So I need clarification on that, because this is really, really restrictive. So I would suggest that we get consultation back on the actual liability. I just don't know how you establish that when you haven't even set foot on a site.
Well, if I could just add that, and that with Caledon, they stopped that, and they were doing drive-bys only, okay, for that. And that, then it becomes, if you're paying 55 cents a kilometer, and that because they had to be reimbursed for it. They wanted them to have proper ID. They wanted them to wear safety boots, hard hats, and everything if they're going on properties because of liability. Now, if you go out on a Saturday and you're driving your boat, and you happen to go by one, that's a little bit different than doing an actual site visit. And as it says, all members are supposed to have the same information. So if somebody goes by and the other 5 don't, and that is different information. And that, so this is why a lot of the municipalities and yes, there is a difference. Some municipalities do site visits. I know when I was in Callan, we did go as a group around. We did not discuss them, but we were putting about 170 kilometers on, and it would probably be that or more up here if you're doing site visits. 6 individuals going to do site visits, paying, and I think it's gone up to 62 cents a kilometer now, would put quite an expense on the township. And that, but if you go on somebody's property without their permission, you're trespassing. And this is one of the reasons why they brought it in. But like I say, I don't have a problem with somebody going out on a Saturday or Sunday and driving by a place. I know if there's something on the Brackenridge Road and I'm coming over to township, I don't go all around. I drive by. It doesn't mean I'm viewing it. And that, but I see Mr. Pink has his screen on. David?
Thank you, Chair Edwards, and good morning, committee. I just wanted to clarify a few of the earlier comments, and I think, Chair, you've largely done that. I think there's a distinction between formal site visits and entering onto properties, and Member Rogan concerns and Member Bridgman's concerns about simply driving by or boating by. Staff are authorized to enter onto the property, and we're able to do that. And as Mr. Sharp pointed out, have proper health and safety training and policies in place regarding that. But with respect to members, that permission does not exist. So you'd have to be permitted onto the property by the property owner. And then you should not engage in discussion with said applicant or property owner, which I think staff finds not overly practical or feasible. I think inevitably some discussion will inevitably ensue. However, should members wish to drive by or go by on their own accord, I think you're able to do so. I think the liability rests with you, and currently the township has no mileage reimbursement policy for those endeavors should members wish. I hope those comments help clarify the discussion.
So then, Mr. Pink, what we're saying, if we pass this, it doesn't stop anybody from driving by or that. It just says we're not doing site visits. That's correct?
That's correct. I think what staff are looking for is clearly in the procedural line to indicate that committee members are not to visit on the property themselves. However, again, we couldn't control nor do we want to prevent any member from being able to drive by any part of the township or boat by. That's your own prerogative. I appreciate the concerns too about having different information, and we discussed that at length over time, and that's difficult. Obviously, every member is going to be a little more familiar with an area of the township than perhaps another member is. I don't think that makes an unbiased or uneven committee or decision. I think so. Again, if we're not looking to prevent members from driving by the community, simply just updating the procedural bylaw to make it clear that members cannot formally do formal site visits onto properties. Staff, again, as Mr. Sharp and the report points out, take extensive photographs and detailed descriptions in our staff reports. So we answer committee's questions, and we're happy to go back and visit sites if further information is needed.
Are there any other questions or comments? No one else? Okay, I have a resolution here. Moved by member Quinn, second by member Brown. Be it resolved, the Committee of Adjustment recommend to Council that bylaw 2015-54, being a bylaw to govern the proceedings of Committee of Adjustment, be amended to prohibit site visits by committee members. Any questions or comments? All those in favor? And that is carried. Okay, thank you. And now, Mr. Sharp, the OCA conference is coming up in Niagara Falls, I believe.
Okay, I'll find out some information and send it out to committee members if anybody wants to attend.
Okay, yes, and that now, yes, member Bridgman.
Would you have the dates for that, Kitty?
I'll find out and send it to you shortly after the meeting.
I believe it's June the 4th. Is a Sunday. It starts June the 4th. It's Sunday, Monday, Tuesday, and Wednesday to the 7th. It's in Niagara Falls. I believe it's the Sheridan. Just a second. I might be able to pull it up.
June 4th to 7th in Niagara Falls.
Yeah.
I'll send out the information package to everybody and you can let me know if you're interested.
Okay, very good. And is there any other new business? Just a minute. I'll have to get out of that screen. Okay, and is there, if there's no new business, I'll read the following resolution. Moved by member Stokes, second by member Bridgman. Be it resolved that Committee of Adjustment meeting adjourned at 11:15 a.m. All those in favor? And that is carried. Okay, well, thank you very much. We'll either see you at the next meeting.